Good afternoon, everybody. Welcome to the sixth installment in the second year of the Law Offices of Melissa A. Day's live webinar series. My name is Melissa Day. I'm the owner and managing attorney of what we refer to as LOMAD, and I'll be your presenter for today. Before we get started with today's topic, I just want to address a couple of housekeeping topics. Initially, this is an invitation-only webinar series, and we've designed it for busy claims professionals looking for a fast and convenient way to keep on the very cutting edge of claims handling without sacrificing more than an hour of your busy day. Each presentation, including today's, will consist of approximately 50 minutes of lecture and 10 minutes that we've reserved for questions. Because we are presenting and recording for the first 15 minutes, you will be muted upon entry into the webinar if you have turned on your audio. At the end of the 15-minute lecture period, I will unmute you so we can hopefully have a nice chat about today's topic. As I mentioned, we are recording this presentation for future viewing. If you have to leave suddenly in the middle, or if you know somebody else who might enjoy or benefit from the presentation, and we'll make that available after the presentation. We also encourage you, although we're going to defer questions until the end of the 50-minute period, to submit questions via the live chat function. If you look for a balloon, like a cartoon balloon, as part of your RingCentral Meetings web interface, the software that we use, you can submit questions through the chat function. Lastly, since this is an office of legal professionals, it's time for our legalese disclaimer. This presentation is being offered solely for informational purposes, and any statements or analysis provided herein is not intended as a legal advice, nor does any attorney-client relationship developed as a result of this presentation. For those of you who are participating today and looking to obtain continuing legal education credits, number one, we have been approved by the CLE board for CLE credits, and your first code is ZN5. I'm not sure why that is not popping up in my, there we go. Okay, so the first code is lowercase z, lowercase n, and the number 5. Today's topic is arising out of and in the course of employment. We're going to start today's discussion with looking at the statutory provisions, because the requirement that an injury arise out of and in the course of employment is contained in a couple of sections of the statute. One of them being section 2.7, which defines many of the terms that we use in workers' compensation. And that section defines injury as meaning only accidental injuries that arise out of and in the course of employment. There are exceptions, as with everything in workers' compensation, and then exceptions to the exceptions. The exception is that the term injury and personal injury shall not include an injury which is solely mental, which is based on work-related stress, if it's the direct result of a lawful personnel decision. That's the stress exception. With the 2017 reforms that were just enacted, the board has, the legislature has created an exception to the exception, which is that first responders now under Workers' Comp Section 10, subsection 3, subsection B, now provides that first responders, so EMTs, firefighters, police officers, who respond to a horrific accident and who develop a stress-related, solely mental injury, their claim will not be disallowed solely as a result of the evidence that the stress to which that officer or first responder is exposed is not greater than the stress experienced by those similarly situated. Incidentally, with occupational diseases, the statute defines occupational diseases as a disease resulting from the nature of employment and contracted therein. So it does have its sort of correlative arising out of and in the course of employment. requirement, but as we saw from our webinar on occupational diseases, you know that there are different requirements for proving an occupational disease. Whoops, excuse me in my technical difficulties with my presentation. An additional statutory provision which addresses arising out of and in the course of employment is Section 10. And that section provides, it's the general section of the statute which requires an employer to provide for benefits when somebody's injured at work. And so that section specifically says that every employer shall secure payment of compensation to his employees and pay or provide compensation for their disability or death for injuries arising out of and in the course of employment without regard to fault. So when you hear people or case law referring to a workers' compensation as being a no-fault statute, this is really the genesis of that characterization. In the course of employment, and analyzing whether or not an injury occurs in the course of employment really relates to the when and where of the accident. So in other words, was the employee on the clock at the time of the accident? Was the employee being paid? Did the injury occur on the employer's premises? Or did the injury occur at a location where the employee was expected to be performing the work they were hired to do? So arising in the course of employment, you can think of in general terms, relates to where and when the injury occurred. Arising out of the course of the employment pertains really to the what and the why of the injury. So in other words, what was the employee doing, or why was the employee doing what they were doing at the time the injury occurred? You can think of the criteria for proving out of the course of employment as relating to whether the employee was performing the duties for which he or she was hired at the time of the accident, and whether or not there's a nexus between the injury and the employment. Some general principles that I'd like to touch on, which really addresses both components of what we're looking at today, both out of and in the course of employment, is that the terms arising out of and in have a clear and definite meaning, and an award can only be made under the statute when the injury arises out of both. So it's not an either-or situation, it's the accident or the injury must both arise out of the course of the employment and in the course of the employment. Another general principle of which we should be aware is that as with many of the requirements under the workers' compensation law, the words arising out of and in the course of employment should be given a broad and liberal interpretation. And that is, as with many things, to achieve the broad humanitarian objectives of the remedial nature of the workers' compensation statute. That language is used over and over again in interpreting the statute, given that the legislation itself, as originally enacted, was meant to be ameliorative and to accomplish a broad public policy purpose of compensating individuals who are injured while they're working. Last general principle of which you should be aware when looking at arising out of and in the course of employment is that there are presumptions that if the injury occurred in the course of the employment, there's a presumption that it also occurred out of the course of the employment. And that is a requirement that's read into Section 21 of the workers' comp statute, which describes the general presumptions that an employee is entitled to regarding interpretation of the statute. So one of the presumptions under Section 21 is that the claim comes within the provision of the chapter. So when you're defending a workers' compensation claim, you face a pretty significant disadvantage compared to the claimant, since there's a presumption from the get-go that the injury arose out of and in the course of the employment, and that the injury occurred in the, or that it comes within the provision of the chapter. In other words, it comes within the provision of the workers' compensation law. There are additional presumptions contained in Section 21, a couple of which address or pertain to whether or not the accident arose out of the course of the employment. And we're going to take a look at those a little bit later on when we look specifically at arising out of the course of the employment. But first, we're going to examine in the course of the employment. So as we said before, since this analysis pertains to the when and where of the injury, if the employee is on the clock, then the injury arises in the course of the employment. The converse of that is not necessarily true, as you might surmise, that if the claimant is not on the clock, it doesn't necessarily mean that the injury didn't arise in the course of the employment. Excuse me. So one of the issues that arises frequently with determining whether or not the claimant is in the course of his employment is when the claimant is at lunch or on a break. And the general rule with lunch is that injuries that occur during a lunch break are sort of in general terms determined to be outside the scope of the employment because they're not in the scope of the employment except under limited circumstances. But as you might guess, there are lots of vagaries in the law and in the facts which could change this analysis. But with a starting point is that if the claimant is at lunch, not a break, but at lunch, the general rule is that the injury does not occur in the course of the employment. However, if the claimant is at lunch and the accident occurs on the premises, the employer's premises, then it's likely going to be determined that this occurred in the course of the employment, even if the employee was clocked out for lunch. And that is because the general rule for these cases where the employee is still on the premises at the time of the injury during a lunch is that the employer has what we call constructive control over the employee. So in other words, the employer still retains direction and control over the employee even though they're punched out if they're still on the premises. Now, as with many of the decisions with workers, the board panel and workers' comp, you can find decisions by the board panel which reach the opposite result. And so in Rite Aid Corporation, the case that is summarized in the current slide that you're looking at, the claimant was injured at that time on an unpaid lunch break on the employer's premises, and they were leaving the break room in order to go back to get some vitamins that was the claimant wanted to take for personal reasons. And the language in that decision was that the merely fortuitous circumstance that the injury occurred on the employer's premises is not controlling to make the injury work related. So even though an injury may occur on the premises, and the general rule seems to be that the board will interpret the employer as having constructive control over the employee when it occurs on the employer's premises. Each case is fact specific, and there may be some facts which would tend to defeat that general presumption that the employer retains control over the employee even if the injury occurs on the premises. So in other words, if you have an employer who's got a break room or even like a commissary or a cafeteria where they sell lunches to their employees, but there is no requirement that the employee purchase lunch from there, and that cafeteria is open to the public at large, you may be able to defeat the finding that the lunch is compensable because the employee is still under the constructive control of the employer, depending upon what facts you can show. Lunch off premises, so this reverts to the general rule that if you sustain an injury off premises, this is likely going to be found to not be compensable. So this is the flip side of, or reverting back to the general rule, which is that lunches in general are, when an employee is on lunch, it's generally deemed not to be compensable. And the fact that somebody is on the clock may or may not defeat that finding of compensability. And again, I would say that it would depend upon how strong the showing is that the employer retained constructive control over the employee. Breaks differ from lunch breaks in generally the duration of the break. And the board finds that accidents which occurred during an employee's short break, such as a coffee break, are generally considered to be so closely related to the performance of the job that they don't constitute an interruption of the employment. Now, can I envision a circumstance where you'd have a stronger argument that during an unpaid break off the clock, where employees are permitted to leave the premises, where that the accident did not occur in the course of the employment? Absolutely. These are all pretty specific, and it's hard to come up with a binding, hard and fast general rule which doesn't have exceptions, like many areas of the New York's workers' comp. Okay. Another situation where the issue frequently arises about whether the claimant is in the course of the employment is in claims arising out of travel to and from work. And with the advent of telecommuting and the increase of workers, like in what we've come to call the gig economy, and just the more flexible arrangements that employers and employees are reaching with respect to how to structure the employment relationship, you can imagine that this too is becoming a fairly complicated area. So the general rule is that travel to and from work is not compensable. This is because employees are not deemed to be within the scope of their employment while traveling to and from work. And the rule essentially recognizes that the risks inherent with travel are only marginally related to the employment. Now, travel to and from work when the employee works at home and at work. So you have a situation where you have an employee who works both at the office and at their home on a regular basis. The board recognizes, and the courts have recognized that while the risk of travel to and from the workplace is usually not in the course of employment itself, such that injuries sustained during travel are not compensable, that in a situation where the work at home is so regular or is so related to a specific task that an employer has requested the employee do at home, that if the work at home, it becomes for the employer's benefit, such that travel to the home could be seen as arising out of, or excuse me, in the course of the employment. The distinction should be made with outside employees. Excuse me for a minute, I just need to, okay. Outside employees are employees who have no fixed regular place in which their work is done. This goes back to the days of traveling salespeople, and we still, of course, today have employees in the workplace who have no fixed place of employment. Those employees are generally entitled to what we refer to as portal-to-portal coverage. And so when they begin their travel from home toward wherever their first destination is in connection with their employment, they're entitled to coverage. And so as a result, any injury that they sustain once they leave the portal of their home until they get back to the portal of their home is deemed to be compensable. When an employee can be characterized both as an inside and an outside employee, and when work is authorized to be conducted after regular business hours if necessary, the employment can continue until the employee arrives at home. So you could think of workers' compensation attorneys or representatives who appear at the board as being both inside and outside employees. where they have to appear both at specific locations in connection with their work, external to the employer's location of business, and also report to the office on occasion. The next variation or hybrid of this scenario that we have some guidance on is when you have an outside employee, so someone who doesn't have a fixed work location, who also works from home. And remember, the general rule is that they're entitled to portal-to-portal coverage, such that when an injury occurs during the travel from the claimant's home to a particular appointment, and then requires travel back to the home at the end of the day, generally these are going to be found compensable. This is, with the rise of telecommuting, a very, I think, hot topic recently, which is when you have an employee who only works from home. And I recently attended a conference where this was a topic of discussion, and it was posited that one of the reasons we haven't seen a ton of case law interpreting, even board panel decisions interpreting injuries sustained by employees who only work from home, is that by and large the situation can be seen to be for the convenience of the employee. Although it certainly could also give a benefit to the employer by having the employee work at home, such as with reduced overhead costs. But that convenience may act as a natural deterrent for people from filing workers' compensation injuries, because people want to continue to be able to work from home. You can also take some steps, if you're allowing people to work from home, to help define the nature of the relationship, and to generally require that your employees work at the office, and that should an employee choose to work from home, that it is for their convenience, not for yours as an employer. So what the one board panel decision that we found, which does address the issue of employees who work only from home, is IBM Corporation, and that relied on this decision in Bonus, which is sort of the seminal decision. It involved a New York State insurance fund hearing rep who was injured and did performed work both at the board, obviously, in connection, had to travel to and from their home, but also had a home office. So Bonus is really the seminal decision at the appellate division, which deals with home office injuries. And so the court, or the board rather, in IBM Corporation relied on that home office exception from Bonus, and finding that when you have, when an employee's home has achieved a status where it's a place where they regularly work and where they have equipment in order to perform work, and it was beneficial for the employer to have the duties performed at home, then an injury an injury at the home could be compensable. And that really kind of is not a surprising result. The questions arise is, for me, when I worked at home, when I first opened up my office, if the dog needed to go out, or if I was, doing a load of laundry, I guess the gray area is when, if I would get up from my desk and go in my home to perform some personal task, whether or not that, and an injury occurred while performing that task, whether or not that injury would be compensable. And my supposition is that the board will look at the reasonableness of the deviation, and we'll talk about deviation a little bit later, in determining whether or not compensation should be paid for that. Special errands is a situation or principle of law that's developed under this case, under these cases interpreting arising in the course of the employment. And that is when an employee who is on a work-related errand and is injured while traveling between work and home and then is injured on that trip has an injury. So in other words, the employer asked the employee to stop on their way home to pick up some supplies for the office. And so there is a two-part test, which is whether the claimant was actually actually performing the special errand that was requested by the employer, and whether or not the employer actually solicited or encouraged the employee to perform the special errand. So this situation can arise when you have a teacher who stops on the way home to pick up some art supplies for his or her classroom. And the question arises, well, certainly that could be a benefit to the employer for that errand, but did the employer actually encourage or solicit the employee to pick up those supplies on the way home from work? And if that prong of the test is not met, then the employee may be denied benefits. There is an exception to the outside employee rule that travel to and from work is generally not compensable, and it arises in situations where you have nurses, certified nursing assistants or home health aides or traveling nurses who are reporting consistently to a fixed location. So they're taking care of the same patient 5 days a week, and they report to that same patient for essentially all their full-time work. A board panel decision has held that that really takes the employee outside the purview of being an outside employee because they so regularly perform their work at a particular work site for an extended period of time. So, what is considered an extended period of time, what is considered regular work at a particular work site is going to be dependent upon the facts of the case. But I think that if you could show that the employee, even if it was only the second day of the assignment, if you could show that there was a reasonable expectation that the employee was going to report to the same location for the next 6 weeks, then you might be able to convert a situation where the employee would be entitled to compensation as a result of an injury during travel because they're an outside employee into an employee who really has a fixed location. When travel is paid, the appellate division held in Holcomb versus Daily News that where the transportation is provided on a frequent and regular basis, and it provides some benefit but to the employer by ensuring timely work attendance or something else, then the employer is deemed to have assumed the responsibility of transporting the employees to and from work, and an injury which occurs in the result of that, as a result of or during that transportation will be deemed compensable. And I can think of situations, fact patterns where the employer provides a bus in order to transport employees from a location to, say, a farm, like a migrant farm, or provides transportation for a group of individuals to a fixed location, that those injuries could be compensable even though they occur during travel. Okay, and I'm sure that many know that there's a gray area that we talk about in determining whether or not an injury that occurs on the way to employment is compensable, and that is that where the risks of street travel merge with the risks attendant with employment, versus the mere fact that an accident took place on a public road or a sidewalk, this can affect whether or not the employee is entitled to compensation. So in other words, the closer you get to the actual employer versus being traveling and encountering a risk that the public in general encounters, is going to that's going to be your gray area, and obviously the more closely aligned the risk of the injury occurring is one shared by the public, the likelier it is that that's going to be not compensable, whereas the less likely that a member of the public would sustain an injury because you're close, you've gotten close enough to the employment that it's a risk intended only to the employees, the likelier it's going to be compensable. And those are referred to the gray area cases. Okay, so now I'd like to turn to injuries that occur out of the course of the employment. This is the why, and the courts and the board describe these injuries as being a natural incident of the employment or one of the risks connected with the employment and flowing therefrom as a natural consequence of the work. And there's a citation there for a case which discusses that standard for you. Again, as with in the course of the employment, there are statutory provision. The statutory provision, which is specific to out of the course of employment, is really the exception to Section 10. And remember, Section 10 is the section which basically provides for compensation for injuries that occur for injuries that arise out of and in the course of employment. Well, Section 10 provides a number of exceptions, and those exceptions really go to whether or not the injury arose out of the course of the employment. And so Section 10 provides an exception for when the injury has been occasioned solely as a result of intoxication from alcohol or a controlled substance, when the injury is occasioned by the willful intention of the injured employee to injure themselves, to bring about the injury of themselves or another person, and when the injury is the result of voluntary participation in an off-duty athletic activity. Really, all of these exceptions contained in Section 10 are exceptions that relate to whether or not the injury arose out of the course of the employment. And as we talked about already, there are exceptions to the exceptions to the exceptions. And in 10, there is an exception to the voluntary participation in an off-duty athletic activity. And that we're going to take a little bit, we're going to look at that a little bit more in depth in a minute. Let's take a look first at intoxication. And as many of us know, this is an extremely difficult standard to overcome, which is particularly, I think, annoying from a defense perspective, because it doesn't seem that somebody should be compensated for having an injury for which their intoxication is only part of the reason that they have sustained an injury. However, as we discussed earlier, compensation by and large it's a no-fault statute, and so no fault is taken literally, and so unless the injury is solely as a result of the intoxication, then you're not going to prevail on that defense. But just think about that for a second, because although we describe comp as being no fault, really, if somebody becomes intoxicated and their intoxication is the sole reason for them having an accident, then we have assigned fault to that employee and they're not going to recover. I mean, if it was truly a no fault, then the fact that they were intoxicated and the intoxication was the sole reason for their injury should not prevent them from collecting compensation. So even though the statute is described as a no-fault statute, concededly intoxication is a very difficult defense to prevail on, that doesn't mean that we're not necessarily able to overcome that presumption that the accident arises out of and in the course of employment. And I mentioned earlier that Section 21 provides some presumptions, and a couple of those relate to issues related to whether or not an accident occurs or an injury occurs out of the course of the employment. One of those is intoxication. And so Section 21, in addition, it does include a specific presumption that the injury did not occur solely as a result of the intoxication. So if it wasn't hard enough to prove that the injury occurred solely as a result of the intoxication, there's also a presumption that it didn't. So this is a very difficult defense to prove. However, I believe that you can use intoxication in combination with other theories to challenge the compensability of the accident. So rather than focus solely on, excuse the pun here, but rather than focus solely on whether or not the intoxication was solely the cause of the accident, use the intoxication in conjunction with other defenses, and we'll talk about that in a second. Willful intent to injure oneself or another. You can think of this arising in situations where an assault is, the employee comes in and assaults another employee. These can also be disallowed because many times the board will find that the fight arose from purely personal reasons. But certainly an employee under the facts of Mattias versus Donmore, where the employee came in specifically looking for another employee because he was angry with him and attacked that employee with a knife, that when the first employee was hit with a piece of wood and sustained injuries which led to his death, the board was entitled to find that that was a willful and deliberate act, making the employee's injuries a result of a willful intent to injure himself or another person, and leading to a disallowance. Voluntary participation in an off-duty athletic activity. This is when, you know, there's a company softball team and the employee is injured sliding into second base. If the participation is voluntary and not considered part of the employee's duties, then the injury sustained during that voluntary participation in an off-duty athletic activity is not going to be compensable. The exceptions to that rule are statutory, and that is that if the employer requires participation, if the employee the employer pays the employee to participate, or the employer otherwise sponsors the activity, which is defined in the case law as being overt encouragement, then the injury can be compensable. So the mere fact the employer might know of the activity and acquiesce in it is not sufficient to amount to overt encouragement. So just an example, in my own world, last Monday, myself and a couple of attorneys in my office participated in a golf tournament that I paid for our admission, and certainly encouraged my employees overtly by offering to pay for them and allowing them to get off of calendar last Monday. That would certainly, I believe, be deemed to be overt encouragement. I'd like to give you your second code now for those who are seeking continuing legal education credits, and that is lowercase m, lowercase j, capital V as in Victor, lowercase m as in Melissa, lowercase j as in Jumping Jack, and capital V as in Victory. Okay, I mentioned earlier that if an injury arises out of a situation which is deemed to be purely personal, then it can be determined to be not arising out of the course of employment. And again, that makes sense. I mean, if there's no nexus between the employment and the injury, because the injury arises out of a dispute which is purely personal, then it can't be said to have arisen out of the course of the employment. Similarly, injuries which are the result of horseplay, and this is a specific concept under the decisional authority. Sorry about the premature forwarding of the slide there. That if an employee is injured during horseplay, then unless it's something that's so great of a deviation from the employment, if it's simply a momentary abandonment of work to play or tease someone, it can be found compensable. And in this decision, Lubrano versus Melinet, the claimant was a 16-year-old youth who was employed as a gas jockey at a service station when he sustained an injury. During working hours, a fellow employee showed him that it was possible to toss a lighted match into a bucket containing a residue of oil and gasoline and grease without causing an explosion. This was a trick that had been previously played on other employees, either by a third employee or by the owners of the station. 2 days later, the claimant was visited at the station by a friend, and during an idle period in which he was waiting for customers, he attempted to repeat the trick that a co-employee had shown him in order to impress his friend. But in this time there was an explosion, and it caused extensive burns to the claimant. And the board determined that these injuries were a product of cumulative horseplay, and as a result were compensable. And so, in other words, it wasn't so great a deviation from the employment that the injuries were not determined, or were determined to be non-compensable. So deviations from employment, momentary, short deviations from the work routine, especially for a customary and accepted purpose, are not going to bar a claim for benefits. And this really goes to the reasonableness of the activity. I want to discuss reasonableness in a minute. Okay. Work rule is a line of cases and a theory on a defense which relates to the distinction between how the work gets done as opposed to the actual work that the employee was hired to perform. So these situations arise where you have an employee who disobeys a work rule, and it could be a safety work rule. And frequently employers want to challenge the compensability of these kinds of injuries because I think that a level of dissatisfaction with the idea that an employee's disobedience of a rule which was specifically created to ensure the safety of employees is violated, and then an injury occurs. Those are particularly, I think, distasteful to an employer, and certainly to defense counsel in defending. If you can demonstrate that the work rule, the conduct of the employee deviated from the scope of the employment to be performed, as opposed to relates to the manner in which the work was to be performed, then you could feasibly prevail in a situation like that. So we've raised this argument when there are the employee is hired to perform a duty for the employer which is prescribed by statute. So in other words, a truck driver who is hired to drive for an employer in accordance with the Federal Motor Carrier Safety Act. I can't imagine any employer who would hire a driver and allow them or want them to not drive in accordance with the FMSCA, because that also exposes the employer to reporting and to potentially cumulative issues. And so it's not simply the manner in which, and there's an argument that it's a violation of the Federal Motor Carrier Safety Act is not just a violation of the manner in which the work is performed, but and that it's outside the scope of the employment, and so therefore an injury that occurs as a result of that failure is arguably outside the course of the employment. The success of such a defense is rather tenuous. However, that doesn't mean under an appropriate circumstance that you might not want to raise that as a challenge to compensability. Also, putting in here idiopathic injuries. These are those cases where you have somebody who's simply walking down a hallway and they sustain a spontaneous Achilles tendon rupture, or without any twisting activity or any torque placed on a joint, sustains a pain in their knee. Sorry about that. There is some authority which would provide a defense if you can demonstrate that the injury is purely idiopathic, and I would say you really need to have medical evidence to back that up. And that, in other words, the injury that occurred it was simply fortuitous that occurred at work, and there's no nexus between any duty that the employee was performing at the time of the injury and the injury. All right, I said I wanted to revisit unreasonable behavior versus, excuse me, the boards and the boards and the legislature's determination that workers' comp is a no-fault statute. And even though it's no fault, sometimes the behavior an employee's behavior is so unreasonable that despite the fact that the statute's a no-fault statute, the board will essentially assign fault to the employee and disallow the claim. And there's a couple of different theories under which the board, defense theories that the board uses in order to find unreasonable behavior non-compensable. And that could be that the injury arose out of a purely personal situation, that the injury was a result of a willful intent to injure oneself or another, or that the injury is a deviation. But really, my analysis of these decisions leads me to conclude that what the board is finding in those situations is that the employee was at fault, that their conduct was so egregious that it is impossible to find a nexus really between the employment and the injury. So depending upon the facts of your case, you may be able to construct a defense under one of these theories where you can argue that the employee's conduct should lead to a disallowance because it was purely personal in nature, because it was a willful intent to injure oneself or another, or that it amounted to a deviation from the employment. And I just want to give you a couple of fact patterns as examples for my conclusion that in some instances the board is assigning fault to the employee because their conduct is so egregious that their injuries should not be found to be compensable. So in the first case, which is Maher, M-A-H-E-R versus New York State Division of Budget, the site for that is 7283rd 1380. It's a 2010 third department case. The employee was attending the first day of a 2-day training conference, and it was actually at the Gideon Putnam Hotel, which was where I was at the end of last week, coincidentally. But that individual and a bunch of fellow employees, they took a shuttle into downtown Saratoga, and they visited a couple of bars on Carolyn Street. The individual did have some alcohol, but likely didn't consume enough where the subsequent injury could be said to be solely as a result of intoxication. However, what the employee did do is at midnight, they took a taxi back to the Gideon Putnam, and they worked their way to a second floor suite, and then the claimant stepped out onto the roof of the hotel, which was only accessible via a bathroom window from the suite. And after about 20 minutes, the claimant placed her hands on the railing surrounding the roof, heard a crack, and then fell to the ground below. And the board found that this was not compensable, basically because it was determined to be so, the claimant's conduct was determined to be so unreasonable that it could not be said to have arisen out of the course of the employment. I have another board panel, and that was an appellate division case. I have a board panel decision where the board used the willful intent to injure oneself or another defense, or exception rather, of Section 10 to find that an injury wasn't compensable. And again, it really went to the reasonableness, I believe, of the employee's conduct and the credibility as well. In the case New York City Housing Authority, which is WCB number G0256583, and I have a Westlaw site for that. It's 2011 Westlaw 1653107. The claimant, it's not really clear what the claimant was doing or why he felt that picking up a mortar that he supposedly found in the street while he was working and then either smoked a cigar near enough to the mortar or purposely lit the mortar. The claimant gave varying different explanations to the employer and to an investigator, like a criminal investigator, as to how the accident occurred and what he was doing, that the credibility really was an issue. But what wasn't an issue was that the mortar exploded in the claimant's face and caused him some significant injuries. And what the board found was that the claimant's intention in lighting the mortar was willful and intentional, and as a result, the injury sustained as a result of that mortar exploding was a willful intent to injure himself or another person. Actually, just one more example on that. There was a situation where, again, the claimant had a couple of alcoholic beverages, was out of town in a training, staying at a hotel, returned to the hotel, continued to drink, and at about midnight decided to go swimming, stopped in his room, met with a couple of co-employees, by the entrance of an indoor pool, found the indoor pool door locked, and proceeded to the outdoor pool. The outdoor pool was enclosed by a 4-foot-high fence, and the gate was chained and padlocked. There was a sign posted in the vicinity of the outdoor pool that said that normal pool hours terminate at 9:00 p.m. And remember, this is around midnight. The pool area was dimly lit. The claimant scaled the 4-foot-high fence and dove into the shallow end of the pool without taking note that the pool had been partially drained that day and to be closed for the season. And tragically, the employee fractured his neck and was rendered a quadriplegic. And in that case, the board, again, found that this amounted to a deviation. In my estimation, what the board was really finding was that the conduct was so unreasonable as to destroy the nexus between the employment and the injury. Okay, I'm going to wrap up pretty quickly here because I see that I'm already dripping into our question and answer section. So what I would just say is that many times you can use credibility issues to challenge findings that the claimant's injuries arose out of or in the course of employment, and those are those situations where you have inconsistent histories. You know, the claimant doesn't report the injury until after a long day or a long weekend, when you know, maybe told some co-workers that his knees were hurting because he did gardening all day the night before. When an injury is an afterthought, those are those situations where you have an employee who is fired and then lo and behold remembers following the exit interview that they had a workers' comp injury 2 weeks earlier. And fraud. And what we do, or what we recommend, is that you use credibility issues and even fraud itself to challenge compensability, either on an arising out of or arising in the course of employment. Okay. So inconsistent histories can be the basis for a credibility challenge for arising out of and in. The afterthought defense itself is a fairly powerful defense for those situations where you have an employee who raises an injury or workers' comp injury after they've been terminated. And I'll give you the third code now for continuing legal education purposes, and that would be capital U for uranium, lowercase g as in George, and lowercase b as in boy. Again, that's capital U as in uranium, lowercase g as in George, and lowercase b as in boy. We also recommend raising fraud as part of your case in chief at the threshold when you have inconsistent histories or credibility issues. While you may not get a disallowance outright as a result of raising fraud, you may be successful in demonstrating that the claimant should be precluded from any indemnity benefits. Or alternatively, fraud as an issue can be used to just challenge outright the credibility of the claimant in demonstrating the essential elements of the accident. Please be aware that if your notice of controversy is not filed timely, and that is within 25 days of the notice of indexing, that acts as a bar to you from pleading that the injury arose out of in the course of employment. We recommend that you strategize on these kinds of cases because there is a lot of ammunition out there, which, if something doesn't pass the smell test, depending upon the particular weakness, potentially of the facts that the claimant's presenting as part of their position that their claim is compensable, can be attacked. And if anybody has any questions, I know I raced through that a little bit at the all, but I'm going to unmute everyone right now. And so I would ask if you have any questions that you let me know.
Hi, Melissa. This is Mark. How you doing?
Good, Mark. How are you?
Okay, I have a couple scenarios for you. You talk about physical injuries. I'm thinking about mental injuries. Suppose you have two coworkers. One perceives himself as doing the heavy lifting. The other one, he perceives his coworker as slacker. And finally, they have it out one day. No fists are thrown, no physical contact, but they're slamming, throwing. And now the second person now feels offended and is mentally damaged, theoretically, because he got yelled at by his coworker over a work-related activity, really, So would that be like a compensable injury?
So coming fresh off of having perfected an appeal to the appellate division on mental or stress claims leading to mental only injuries, I can tell you that it's a requirement that you prove that the stress to which the employee was exposed is greater than the stress for those similarly situated. And there is good language out there for defending those cases, which says that if the stress is simply the normal annoyances to which all people are subject in the course of interacting with one another, and I'm sort of paraphrasing what the language is, but it's essentially, along those lines, that it does not amount to stress greater than that experienced by those similarly situated. So, I think that your employee who, especially, and like I said, in those situations where the board really looks at the reasonableness of the conduct, I mean, he himself was part of the escalation of conflict, but also just in general, the decisions support a defense based on a lack of stress greater than those similarly situated, because people who come in contact with one another are going to run into conflict once in a while.
Okay, I have another scenario that I investigated many years ago.
Mm-hmm.
It was a lady who worked in an office, a very attractive lady who knew she was attractive, and occasionally she'd have to go into the plant to take papers or do something there. And one weekend when she was in the restaurant with someone, the word got back to her that male workers in the factory loved it when she came out there and had impure thoughts about her. And she was highly offended and made a stress claim. And just as an aside, when I actually met with her at her house, she was dressed in such a way that you couldn't help but notice her. It jaded my opinion about her because she looked like she was looking for attention.
Mark, I think that what a woman is wearing is not really relevant in determining how she should be treated. Certainly, I understand that people can differ about that. However, if she was subjected to unwanted advances, her manner of dress is really not relevant in whether or not she could be considered exposed to sexual harassment. So, if she develops stress,
this is not a direct. This came around on a third party. Nobody did it to her directly. She found out through a third party that these guys were thinking this way, not anybody directly to her.
And then developed what, like a mental injury as a result of that?
She alleged, yes.
That's beyond. I would have to do research on that.
Okay.
That's like, straying into the like the sexual harassment realm, and what kind of conduct is and is not permissible, and the fact that she wasn't directly exposed to that, but then found out about it later, seems to me to be somewhat attenuated. However, given that it's my understanding that those statutes are also ameliorative and meant to be interpreted literally, just like the workers' comp statute, that she may be able to make out a case for discrimination. So whether or not that was sufficient for her to sustain a stress claim, again, it has to be stress greater than that for those similarly situated. Could you style that as a purely personal action on her part because you want to demonstrate that she had some reason to seek out the attention? You would need definitely evidence of that.
Okay, thanks.
Sure. Okay, well, if nobody has any other questions, let me just remind you that our next webinar will be our Breakfast Club series, and that will be presented on June 23rd at 9:00 a.m. and it's Advancing Labor Market Attachment Issues, Advanced Labor Market Attachment Issues, including BATI, which is a decision which finds that if you have no wages to lose at the time that you become totally disabled, you're not entitled to any ongoing benefits. So in other words, if you're unattached to the labor market at the time you become totally disabled, you are then precluded from getting benefits. And that will be presented by the incomparable James Cousins, who will also be presenting our next basic work compensation issues webinar, and that will be on average weekly wage, and that will be presented on July 10th at 12 o'clock. And for both of those webinars, please, as always, sign up for those at hearings@getmad.today. If you have any questions, please feel free to contact me at mday@getmad.today. Thanks, everybody.
Thank you.